Don't beat Medicaid estate planning recovery by gifting your kids a home. What's up, everybody? My name is Josh Key. I'm the managing attorney at Key Law. We take the headache out of estate planning and probate so you can focus on what's important. Before we begin, if you have questions about this or anything related to estate planning and probate and you live in the great state of Alabama, you can speak to an attorney for free by going to keylawllc.com. Now, on with the statement in question. So, why do we not want to do that? And what are we talking about initially? Well, first, when you qualify for Medicaid, and Medicaid and the state pay out funds on your behalf for nursing homes and things of that nature, they will come and will put a lien on a personal residence if there is one available. Medicaid typically is for those that have very, very little funds. They keep track of expenses and money in the account, and they check to make sure that it is below a certain limit during that month. And if you go over, you get disqualified. And then when unfortunately you pass, they will look for assets, specifically a personal residence, and put a lien on that home to try to recover the funds that were paid. So a lot of people think that if they gift their children a home, they won't have to worry about it, and they will avoid that lien or that estate recovery by the state. But it creates some problems. First, there's a look-back period. It can be 4 to 5 years, and basically when you transfer that to a trust sometimes, or to an individual, and you just sign your name over on the house, sign the deed to your children, that total value of the home is counted against you in that look-back period. And that can basically disqualify you when you need it most. So for instance, it used to be, I think it's $2,000, $2,200 a month is what they look for. So you look at it and you think about it, for a $100,000 home, that's a pretty long time before you'd be able to qualify for Medicaid. So that's not always the best. So you really need to be careful with that. And then secondly, even if you do get it outside of that look-back period, you're now gifting it to a child and basically are putting the home, making the home vulnerable to their choices and their lifestyle and anything that's going on in their life. So they could get divorced. Now, the chances of them losing the home in a divorce, in most states is fairly low. Typically, the gift receiver is able to retain that, but it's a possibility. And then you also look at any of their creditors. If the home is bought and paid for, there's a good chance that they could try to come and recoup any monies that are owed off of that. And then finally, and one that I think is very very, very difficult for people to understand, is if that child dies for some reason, whether it's a car wreck or something that's unexpected, that home would then be subject to their estate. And as we've talked about previously, if they are without a will, that home may be split between family members or children or different things, and that may produce some unintended consequences. Also, it may go to a charity, it may go to different things. So that home may not go where you want it to by gifting the child. Now, some of these things can be mitigated with a little bit of trust planning and thinking ahead, and that's where we usually try to help folks. So if you have questions about this or anything related to estate planning and probate, and again, you live in the great state of Alabama, you can speak to an attorney for free by going to keylawllc.com. Again, I'm Josh Key. I'm the managing attorney at Key Law. We take the headache out of estate planning and probate so you can focus on what's important. Like, share, subscribe. We'll see ya.